Here we go. All right. So good afternoon. Hello to everybody here and everybody online. Thanks very much to Andy for organizing this. And thanks to everybody for coming along. So my presentation is relatively brief, but I'm hoping it'll provide some food for thought. Some of this connects up with what we've heard about earlier, actually, and then some of it might set up some things that we might talk about later in the panel at the end of the day. So basically, what I'm going to talk about, I'm cheating really. I'm presenting the articles and then the reflection from a symposium issue that myself and Brian Barry of Trinity College Dublin put together late last year on the theme of law as data, data as law. Brian can't be here today, so I'm deputizing for him on this. And this symposium was published in the journal Law, Technology and Humans, which some of you might be familiar with. That web address doesn't come across so clearly on the slide, but anyway, I should possibly have generated a QR code, but you can look it up easily enough on the web if you want to actually read the articles later, and I would recommend actually that you do read the actual articles afterward. But this, just to explain that's the genesis for this piece. And we put together this symposium because obviously, and I don't need to stress this too much to the audience that are here today, there is a lot of focus on the quantitative analysis of law. And there is also a lot of attention on the translation of law into software, some of which is more in sort of traditional rule-based systems. And I'm actually always more interested in that from a research perspective than I am in the machine learning sort of predictive analytics aspect to it, because I think that one of the things that happens a lot in this field is everybody gets sort of distracted by the shiny new thing and forgets that all the old things are continuing to happen. And so there's a lot of use of law as data and law being converted into a variety of different formats, which are then the basis of automated systems. And essentially what we were interested in, what we continue to be interested in, is what does all of this mean for research, for teaching, and for practice in the law? We didn't manage to answer all of those questions in the context of this particular collection of articles, and I don't think we will ever really answer those questions. That's what we spent a lot of today talking about, and I suspect there will be future conferences where we continue to pick those questions apart. Now, I'm going to do this in two parts. First is I'm just going to briefly present the different articles that were within the symposium. I'm not going to present them in any great detail. That wouldn't be fair or right, because they're not my articles, essentially, but I think you need to get a little bit of a sense of what they were about. And then I'm going to spend a bit more time towards the end, really, with the reflections that Brian and I came up with afterwards. So a lot of these pieces are obviously going to resonate very much with the audience that are here. There was a piece by Paul Burgess and some other colleagues of his on using generative AI to identify arguments in judges' reasons, the accuracy of those systems and the possible benefits for students. So this is very much the sort of thing that Andy is interested in. And they concluded that large language models are not yet accurate enough to identify arguments in journals. With a piece by Niamh Kenshin on the human in the feedback loop, looking at the use of predictive analytics in refugee status determination. And that's quite a detailed piece of work. But the main takeaway, I think, from that is that the choice of the case characteristics, in other words, the essential pieces are the pieces of information that are regarded as essential rather than the essential pieces of information. I think that's the important distinction she's trying to make. That is really quite important in terms of determining the outcomes that might arise from these kinds of predictive systems. In other words, the way that the software developers and whatever experts are working with them choose to decide what aspects of particular cases are to be recorded and converted into parameters and quantified in some way and then fed into the software system, whether it's a predictive AI system or a rules-based system. Those are really important in terms of determining what kind of outcomes are more likely, and that makes sense. That determines how the system essentially sees the world. is a piece by Audrey Plan looking at the challenges of law as research data in socio-legal scholarship. And essentially what she was arguing in this piece is that if law is going to be used as data, if actual legal rules or the accumulation of legal guidance, legal rules that might come from judgments from case law are going to be fed into a computer system, then attention needs to be paid to the unique characteristics of law. This might connect up with some of the questions that Samuel has talked to us about before the break, for example. Why is it difficult to build these kinds of predictive systems for law? I think a lot of what Samuel was trying to get at is that law works differently to other domains. I suppose every domain works differently in some way. And Audrey's article is essentially talking about the unique characteristics of law, particularly pointing at the way in which the different texts that are used are not necessarily easily comparable with each other. They're not commensurable. That the concepts that we use in law are very fluid. I was speaking to someone earlier, and we were talking about the challenges of teaching undergraduate students, and I was making the point that people often come into law expecting to find black and white answers and to find easy outputs from systems. And one of the things that you need to teach them is the ambiguity and the fluidity of law and legal answers is actually quite important. And that is something that I think is often not understood very well by outsiders. And that the sources of law also are not necessarily systematic. So, if you're going to use law as data, well, what are the data sources? How do you pull all those together? So a lot of questions that's raised by that piece. And the other point I think that article was making essentially was that sometimes we end up with quantitative methods, rather, answering questions because we can, rather than asking the questions that we really should be asking. In other words, we do things with data that are easy to do with data. These are not necessarily useful. And then we had a piece by Prakash and Nair, which basically argues that legal teaching must embrace AI in order to enhance access to justice. And we've heard different versions of that argument over the course of the day. Andy, particularly, I think, would get behind that. But the idea is that there's a lot of opportunities, some challenges, and some risks. But this article is very much a call to action for integrating generative AI into legal education. As you can see, there's a range of different perspectives and different approaches there. And then the final piece is quite a technical piece, actually, looking at prompt engineering strategies for extracting the outcome of cases from, these were from a French data set by Guillaume Zambrano, and basically trying to benchmark the performance of different large language models, and found, contrary a little bit to the Burgess piece, although they were obviously asking different questions, that large language models can be effective at extracting relevant cases from a data set for an initial query. And that has some connection maybe to the work that you talked about with Lexis plus AI as well. Now, to move then beyond talking about what the article said to what Brian and I came up with around that. So we then had the challenge of sort of marinating on all of those different pieces, which is, as I just said, were really quite different in terms of topic and approach and perspective, to try to say something coherent about them. So this is our attempt, and you can decide afterwards whether or not this makes any sense. But essentially, we approached it by asking some of the sort of classic journalist questions. How, why, who, and where were the ones that seemed relevant. We didn't get to ask all 6 of those questions in the end, or at least it just was simpler in terms of presentation to stick to 4. And possibly these are not necessarily going to be surprising to the audience that we have here, but nonetheless, I think that there are some useful lessons or ideas that can inform some of our discussions. So, as I said, there's a diversity of approaches here. And that means that possibly we need a diversity of skills. There's a range of new technical skills that a lot of us don't have, that wouldn't have been a feature of our legal education or training. I'm in a somewhat more fortunate situation in that I actually had a portion of my career working in the IT industry, and I used to have a pretty good technical skill set, but it is all now from the last century, literally. I haven't made my living in that way in 25 years. So even I find it difficult to keep up with what's going on. I don't have the range of technical skills that are necessary. So we need to think about a diversity of approaches, a diversity of skills, diversity of research methods, which I'll come back to towards the end of this. But one of the things that is also important when we think about that diversity, and this comes back really to Audrey Plan's piece, is that if we end up only asking quantitative questions about the law, that is not going to be sufficient in terms of doing the work that lawyers need to do or legal educators need to do. But it is increasingly going to be necessary. So the challenge that we have is how do we develop the research capabilities and develop the teaching capacity to ensure that, first of all, everybody has some level of quantitative and technical skills, but also understands that that's only a piece of the jigsaw puzzle. So the diversity doesn't mean that things go out. It means that new things come in. Rigor also was an issue that came up across the board. It was a strong theme in Niamh Kinchin's piece, for example. And essentially, if you contrast the more skeptical articles in that collection, perhaps with the more positive ones, at least the conclusion that we came to was that there was a need for rigor, that techno-optimism is all well and good, but that needs to be tested by benchmarks. We need to be careful not to get bowled away by the new and shiny thing, but we need to test whether or not this actually does what it's supposed to do and whether or not that does actually lead to better outcomes, better outputs, better results for everybody. The other two themes that emerged, I think, are perhaps, so those two things are probably pretty obvious. The other two themes are maybe go a little bit deeper or maybe a little bit less obvious. But one thing that seemed quite important across all of those pieces, and we've touched on it a little bit from time to time during the day, but I think we haven't maybe surfaced it enough, is who are we doing all of this work for? Who do we work for at the end of the day as researchers or as educators? Are we doing this on behalf of students? Are we doing this on behalf of the marginalized? Are we doing it on behalf of marginalized students or marginalized people? Are we doing it on behalf of the public as a whole, those who may, for example, be discriminated against by existing systems or by new algorithmic systems? Who exactly are we working for at the end of the day? And we did have a presentation earlier from employers, about what they want, and that is quite an important piece of the puzzle. It's a vocational field of study and vocational field of research, and that's where most of our students are interested in. So are they the people that we're working for when we do this? So we need to ask ourselves the question, who are we, on whose behalf are we engaged in all of this work? And the suggestion that we made was that design thinking is a very useful tool for thinking about that, because it forces you to surface the user and the needs of the user and the journey that the user goes through. And then the last thing that we felt that was important, and maybe this was just reflecting the challenge that we felt in editing this particular symposium, is that because of all of this diversity and this new need for new types of rigor that we're not necessarily used to, there's a lot of discomfort. Some of this journey is fun, but it's not always comfortable. It's challenging. There's a need for these new competencies, a need for new disciplines, a need for new research methods. And that takes us then out of our comfort zone as researchers or as teachers. And that really was the conclusion of the piece, of call for people to get more involved in obviously more interdisciplinary work, which is something that's often said at these types of events. So it's maybe an obvious conclusion. But one thing I would say, I suppose, is that although interdisciplinary work has been mentioned a couple of times today, that focus has very much been on working with people from computer science. And I don't think there's anything wrong with working for people from computer science. I work with people from computer science as well. But there are other disciplines like information systems, for example, or science and technology studies, which would have a certain amount of crossover and may not be necessarily at the same level of deep technical skill, although there are people in IS who certainly would have it, but that offer an opportunity to take a different perspective, a more critical perspective sometimes than a more human-focused perspective on research and on teaching in this field, and doesn't seem to get, I think, as much, is not reached for as obviously, I think. So that's my sort of minor provocation to close out the presentation, is to say, if we are thinking interdisciplinary, let's make that mean something more than just let's have somebody from computer science on board. Let's talk to other disciplines and other fields. I think that we could learn a lot from talking to those working with the philosophy of technology, for example, the history of technology, rather than just talking to the computer scientists all the time. Although I have nothing against computer science. Thank